This is a little tip for everybody who is filing for Social Security disability, potentially if you're heading to CDR, but let's just consider when we're filing. And we are using a cane or an assisted device, a walker at times, even a wheelchair. If you think that's going to help your case significantly, necessarily, it's not necessarily going to do that. It is going to oftentimes, and this is even found in case law, only help you if it was medically prescribed, which means it's recommended by your doctor if it's prescribed, versus you knowing you need it. And let's face it, you know if you need it or not, right? So if you go to CVS and get a cane, or crutches or a walker from a supply store, it's because you need it. However, if you don't have the documentation from your provider saying he thinks you need it and why, and stability, alleviate use of a body part more than the other, whatever the case may be, you're going to want to make sure you get that prescribed to you. So even if you've already gotten one because you know you need it, your family and friends told you needed it because you're falling all the time or you're very unstable, perhaps you don't even like to ambulate, walk around anymore because you're worried about falling, but you would be less worried and more independent if you got that device. It doesn't matter whether you actually have insurance that will pay for it. I understand it's easier if you have insurance that will pay for it. But what is really important is that you have doctor's medical recommendation in writing, and a prescription does that. We have seen the use of a cane and a walker or crutches be disregarded altogether by decision makers if they are not prescribed. It doesn't make a lot of sense to me. I don't agree with that, but that is what we're seeing. So if you need it, get it, but get your doctor to put in writing that you need it. Okay. I can't emphasize that more because what a waste. It didn't used to be so much that way, but this has become, a little more recent in the last 2 years, I'd say, that somehow the rule changed of how they're going to consider that. So take heed. It's not that hard. I don't know a doctor who's going to say that somebody with an antalgic gait or back pain who feels they need it doesn't need it. If your doctor says something cute like, he wants a cane, so I'm going to prescribe him a cane, that's probably not helpful. So talk to him about why you think you need a cane if he hasn't already talked to you about it already. If you're, use your own proactive relationship with your provider or providers. If you have an orthopedist versus a primary care, one might be more helpful and proactive on your behalf than the other. You're going to know that better than anybody else. And again, I'm going to reiterate, which I've said elsewhere, this does not mean telling them that you're filing for disability. In fact, as you know, I'm a proponent of not doing so unless you have great reason to do so. And probably the only reason I can think of to do so, short of if your attorney is trying to get a well-tailored, customized response to a customized made interrogatory set. The only reason you'd probably even mention it is if your doctor has already said, listen, you've got to file for disability, you got to stop working, or you really I think that you would win, blah blah blah. But I wouldn't be offering it without that because of the level of bias out there. Not necessarily from the doctor, but you'd be surprised within the doctor's office. Anyway, so I want you to get full use of the fact that if you need a cane, that should be very good evidence for you, but it's not going to be unless it is medically prescribed. Okay, so I hope this helps. And any more things I come across, I'm actually looking at a case right now where it was discussed. So take that home, and I hope it helps you. Bye-bye now.